At the very beginning of your medical malpractice trial, before the jury is brought in, before any testimony takes place, the judge wants to see the attorneys and he's going to ask them, hey, counselors, where are your requests to charge? If one of the attorneys does not have their request to charge, are there any repercussions? Do you want to know what requests to charge really are? Come join me for a moment as I share with you exactly what they are. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And now, when you start a trial, the judge will ask each attorney for requests to charge. Now, what is that? They are requests by each attorney of specific areas of law that each attorney wants the judge to explain to the jury at the very end of the case, after the case is over, when the judge gives the jury legal instructions about what to do and what to focus on. And why is that important? It's because each side has competing interests, and there are different sections of law that each side wants explained to the jury. Some of these sections of law are favorable to the plaintiff, the injured victim. Some of these sections of law are favorable to the doctor and to the hospital. And that's why the judge wants to see them beforehand so he can begin doing research, and he can have his law clerk also begin to do research. So now, as we get close to closing arguments, the judge will actually call the attorneys in for a private conference and go through exactly what each one has requested, and then tell him his decision about whether or not he's going to go ahead and explain this section of law, or he's not going to, or he's going to modify it. And now he'll go through step by step on every single request that the attorneys have asked for. If an attorney does not come into court at the very beginning of the trial with his request to charge, that's a signal to the judge that this attorney may not be fully prepared for trial. Now, in all likelihood, the judge will likely give him an extra day or two to get those things into him. The attorney may have had a good excuse. Hey, judge, I had some problem at home. I couldn't get to it. My computer broke. Whatever it is, the judge will likely give him an extra day or two to get this information in because he needs it, and he needs time together with his law clerk to do the legal research to see whether or not the facts support talking about this section of law that one attorney is asking for. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you haven't started a lawsuit yet because you still have questions that need answers, what I invite you to do is, you know what I'm going to say, right? Pick up the phone and call me. I can answer your questions. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.